Hello, and welcome to another Music Industry Talk. My name is Janae, and as usual, our conversation is with music attorney Cassandra Spangler. In this conversation, we focus on copyright, and we'll discuss a few myths to help keep us all out of trouble. The information provided in this video is for informational purposes only and not for the purpose of providing legal advice. You should contact an attorney to obtain advice with respect to any particular issue or problem. Hello, Cassandra. It's nice to have you back again.
Hi, Janae. It's always my pleasure. Thank you for having me on.
Did you know that we have been doing this now for, in June, it'll be 3 years.
Wow.
Isn't that crazy?
Crazy. Time flies.
We all have so many questions about the music industry because it's so darn complicated.
It is so many layers, and things are constantly changing and there's always new technology. So, it's a learning process for all of us.
So, today's conversation, we were going to talk a little bit more about copyrights. And specifically, there's this article about Ed Sheeran, and he had another lawsuit against him. This is what, like maybe the third or something like that, for a song that somebody claims that he stole. And according to the judge over there in England, the answer was no, he did not steal this song. So this seems to hurt both parties, in my estimation, the person bringing up the lawsuit and the person that's being sued. So maybe at some point we can talk about how filing a lawsuit can actually hurt the person that's filing the lawsuit, especially if it's not founded. But it does hurt both parties, keeping in mind this is over in England, so we can't really talk about the laws over there, but we can apply them to here, right?
Yeah, and so I thought what we could do is maybe just discuss a little bit in general about copyright lawsuits and music copyright lawsuits. And if anyone is interested in sort of a primer on copyright in general, Janae and I did a prior talk on that. So you can check out on Janae's YouTube channel and look for that one. And that may be a good base for you to listen to that one before this one, so you can sort of understand what copyrights are to those people out there listening. So copyright lawsuits basically, as a brief review, which we go into more detail in the last talk about copyrights, but copyrights, at least in the US, are what they call a bundle of rights, which means that if you own the copyright, you have the right to reproduce the work, the right to distribute the work, the right to publicly perform the work, publicly display it, and to create derivative works of it. So whenever you own a copyright, whether it's in a piece of music or a photograph or a book, all of those rights belong to you as the copyright owner. And so if someone does any of those things with your work without your permission, then that can be copyright infringement. And that's where you will see copyright lawsuits, as someone is claiming that someone did one of those things with something that they own the copyright to without getting their permission. And just a little disclaimer, I'm not a litigator. So litigators are attorneys that handle lawsuits. I'm what they call a transactional attorney, so I handle transactional work. So if you have more in-depth copyright lawsuit questions, you would want to consult with a litigator. But just kind of as a general overview, one of the important things to keep in mind is to register your copyrights. So if you're a songwriter or you're an artist or a producer, you want to register the copyrights in your work before you release it, or at the very latest within 3 months after you release it. And the reason for that is because it can end up making a big difference if you ever do need to bring a copyright lawsuit against someone. The benefits of that, I mean, first of all, in the US, you have to register the copyright before you can file a copyright lawsuit. And that doesn't necessarily have to be done in a certain time period, but it has to be done before you can file the lawsuit. So it's a good idea to have it done ahead of time. This way, sometimes it takes a long time for the Copyright Office to process the registrations. So this way it's already done and ready to go in case you do need to bring a lawsuit.
So when we say that you have to file the copyright, are we talking about the PA, the SR, both?
Good question. Yeah. So what Janae is referencing is if you ever go to the Copyright Office website to register your copyrights, you'll see there are different types of copyright forms. And one of them is a PA form, which stands for Performing Arts. And that is for the copyright in the underlying music and lyrics. So if you're a songwriter and you want to register your lyrics or register a composition that you wrote, you would use the PA form. The SR form, which stands for sound recording, that protects the actual sound recording. So if you're a record label or you're an artist and you want to register the recording itself, you would use the SR form. If you are both, so if you're an independent artist who owns your recordings and also writes your own music, you can do it on the same form. I won't go into too much detail with that because it gets a little technical, but just know that, if that's the case, you may be able to cover them both on the same form. But if not, you would want to register both to make sure you're covered on all sides. Because if someone copies your song and uses your recording, you want to be able to sue them for infringing on both the recording as well as the underlying music and lyric.
Okay. Thank you.
So I mentioned that you wanted to register it either before you release it or at the very latest within 3 months after release. And the reason that matters is because under the copyright law in the US, there are certain benefits that you get if you've registered the copyright within those timeframes. And one of the biggest benefits that you get is that if you win the lawsuit, the person who lost has to pay the court costs and the attorney's fees, which can, for copyright lawsuits, they are in federal court and they can take years and years. And the legal fees for the lawsuit can be hundreds of thousands of dollars. So to have the ability to say at the end of the lawsuit that the person who lost has to not only pay you for the copyright infringement, but they have to also pay for all of your legal fees is a huge, huge benefit, because otherwise, for many people, it's just too costly to bring the lawsuit in the first place. But the only way that you can be awarded those court costs and attorney's fees are if you registered your copyright either before you commercially released the songs or at the very latest within 3 months afterward. And the other benefit there is, in addition to the court costs and the attorney's fees, you can also get what they call statutory damages. So there are different types of damages that you can be awarded in lawsuits. There are things that they call actual damages, which are where you would prove that because this person stole your song, you lost out on X amount of money. And that can be very, very difficult to prove, or it may be a very small amount. But then there are something else called statutory damages, which are amounts of money that are set by law. And under the copyright law, they can be up to $150,000. And so if you registered the copyright before you release the track or within 3 months afterward, you can ask that the court award these statutory damages so that you don't have to go in and prove how much money you lost, which can make a really big difference at the end of the case. And also, even at the beginning, when you're trying to negotiate a settlement, the fact that the other side knows that if they lose, they're liable for your attorney's fees and statutory damages can give you leverage when you're trying to negotiate without having to take the case all the way through. So, I know it gets a little technical and it gets into legal jargon and stuff like that, but the important thing to take away is that you really want to register your copyrights before you release anything, because it'll give you a lot of protection down the line in case you ever need it.
And in this case with Ed Sheeran, we're talking at least 4 years.
Yeah, right. It gets extremely expensive and it's also very stressful. And you have this thing hanging over you for years, regardless of whether you're the person bringing the lawsuit or the person being sued, it's still stressful. And, it's just, it's a difficult situation to be in.
Absolutely. And so in this case, if that had happened here and the person bringing the suit actually lost, are they liable for Ed Sheeran's team's legal fees?
They could be. So there are some situations in the US, it's not automatic. In a lot of other countries, it's automatic that whoever wins the lawsuit, the other side has to pay the legal fees. But in the US, it's a little different. There are only certain situations where you can get that. But there are situations in copyright lawsuits where the defendant, who is the person that is being accused of stealing someone's work, if they ultimately win, sometimes they can countersue for court costs and attorney's fees. So you definitely don't want to be in a situation where you're bringing a lawsuit that's frivolous or that isn't reasonable, because you could end up having to pay the other side's attorney's fees. But it's pretty rare for that to be awarded in the United States. Although the flip side, as I mentioned, if you're the plaintiff and you're the one who's accusing someone of stealing from you, if you registered the copyright on time and you win, then you can almost automatically be awarded attorney's fees.
Okay. Unless you have your song and then this other person has their song and it literally sounds like, whole lines have been taken, or I don't know, the music sounds exactly the same. Is it even worth filing a lawsuit?
It's a tough situation because it's so expensive. So a lot of times, it doesn't end up happening unless there's a bunch of money at stake. Although they are in the process, and I don't know if it's been set up yet or not. I think it's supposed to be set up this year, of setting up a copyright small claims court, which is awesome because it means that if it's a small matter and there's not a ton of money at stake, but there still was copyright infringement, it will give you the ability to bring a lawsuit without having to spend two or $300,000 on legal fees.
Interesting. So who would go to small claims court? Can you give an example of a situation where, okay, you would go there?
Yeah, I'm not sure what the limits are. Normally, for small claims court, there's some type of limit. So if it's under X amount of dollars that you're looking for, then you can file in small claims court. I'm not sure what the limit is going to be for the copyright small claims court, which will be in, I believe, Washington, D.C. So I'm sure there will be some kind of limit where if you're looking for under this amount of dollars, you can go ahead and file there. And a lot of times with small claims court, you don't need to hire an attorney. They make it a very easy process where you just fill out some forms, you go and kind of argue your case, and then the court will make a decision. So it's great to see that they're doing that for copyright because it's been so difficult. I mean, I've had many clients over the years where it's pretty clear that something was stolen from them, but they just, there's not enough at stake, or they don't have enough to pay the legal fees to hire a litigator to bring the lawsuit. So I think this is a great thing that they're doing.
Wow, and I'm going to date myself here and I'm going to say it sounds like people's court.
Yes, People's Court, or now they have Judge Judy and all these.
Judge Judy, right?
Yeah.
Okay. Anything else with the Ed Sheeran case?
Yeah, so I mean they kind of mention in there, I think ultimately the court ruled in his favor because it was just something that was a very small piece of music that was supposed to have been stolen, and they said it was just a common chord progression or something like that. So I wanted to talk a little bit. There is something called a fair use defense, which is raised a lot of times when someone is accused of infringing on someone's copyright. They may raise what's called a fair use defense, which basically are some exceptions. So I mentioned at the very beginning this bundle of rights that belongs to the copyright owner, and that you can't do any of those things with a copyrighted work without getting permission. But there are some very, very limited exceptions to that, which constitute fair use, meaning you can use someone's copyrighted work without a license under very limited situations. Things like for purposes of criticism or commentary. So if you wanted to, write a book review or a film review, you can reference parts of the film for those purposes. or things like news reporting. So sometimes maybe the news is covering a story and a car drives by in the background and there's music playing out of the car. Well, if that were a reality show instead of a news show, they would need to either mute out that music or get a license to play it in the background. But if it's news, there's some limited things that they can do without needing to get a license and without having it be copyright infringement. So sometimes you will see these fair use defenses that are raised. And the reason there is, the courts try to balance First Amendment rights to freedom of speech with copyright to make sure that copyright isn't overtaking people's right to free speech and vice versa. I just also wanted to mention, so there are these sort of like common myths about copyright that I'm getting constantly asked about by clients. So I wanted to discuss a few of those. The first is people may have heard of what they call a poor man's copyright, which is basically this process where people mail a copy of something to themselves and they get it postmarked and it's sealed in the envelope. And they think that that is a substitute for a copyright registration, which in fact it's not. So, I mean, it can be helpful to you to do that to help prove the date that you created something. Although nowadays, most everything is digital. So, a lot of times you can prove the date that you created it through the metadata in the computer files. But, before that, people would say, type out a manuscript and then they would mail a copy of the manuscript to themselves to prove that they owned it. And again, that can help you to prove the date because sometimes that becomes an issue in copyright lawsuits. Someone will claim, well, I created this before you, so it's actually my work that you're infringing on. So it can become important to prove the date that you created something, which mailing a copy of it to yourself may help you to do that, but it is not a substitute for the copyright registration. So you still want to make sure you get the copyright registration submitted and you want to do it early before you release anything. So that's kind of the first common myth that people ask. And I think the 2022 version of that is I've seen people try to email it to themselves or email a copy to me and say, can you keep this on file? Because I don't want to register the copyright. And I said, well, this helps prove the date that you at least created it as early as the date that you sent this email, but it's not a substitute for the copyright registration.
Right. I mean, to me, the key word there is registration.
Yeah, whenever you hear register, you normally think of, some kind of government agency needs to be involved. And in this case, it's the Copyright Office.
Okay.
The second common sort of myth that goes around is some people seem to think that there's like some, amount of time. I hear this a lot with questions about samples. So a lot of people are under the misconception that if you sample something and it's less than 3 seconds or it's less than 7 seconds or whatever it is, that it's not copyright infringement. And that is not true. If you use any amount of the original, as long as it's sufficient that it was protected by copyright, then it's copyright infringement. And there's no magic number as far as, the amount that you can get away with using.
Okay. So if I write a song and I want to include part of a Michael Jackson song, Bad, 3 seconds. I just need 3 seconds and it is going to make my song sound so cool. I have to get permission. I have to include that information in the copyright.
Yes, absolutely. Yeah, any amount that you're using, as long as it's sufficient that it's protected by copyright. And what I mean by that is, if you want to use just the word bad, you're not going to, there's no infringement because that word by itself is not protected by copyright. But aside from that, if it's anything that is protected by copyright, there's no magic number that allows you to get out of having to get a license.
And actually, if we stay on that for a second, that does not mean that I can take Michael's recording where he says the word bad and put it in mine.
Very good point. Yes. So if you're using any portion of someone's original recording or someone's photograph, then, you need to get a license. Otherwise, you're infringing on their copyright.
Okay.
And then I guess the last sort of common myth that you hear is a lot, and this one I hear a lot, A lot of people seem to think that if they're doing something for quote unquote non-commercial use, that they don't need to follow copyright rules. So that if they're releasing a song for free online, they don't need to get licenses or anything. And that is completely false. It's one factor that the court would look at if, for example, you get sued and you try to argue fair use. One thing they will look at is whether it was commercial use, but there is no automatic exemption from copyright for things that are non-commercial use. So even if you're releasing it for free online, it doesn't matter. You still need to get a license if you're using any portion of someone else's copyright.
I've also heard that people are like, yeah, but it's for, say, a nonprofit organization. It's nonprofit, so I can just use whatever I want. But that is not true.
Yep. You see this a lot on social media. People will post something that they know doesn't belong to them, whether it's a photograph or a song, and then they'll write, some kind of disclaimer about this is being posted for non-commercial use, as if that gives them an automatic copyright license, and it actually does not. And it's actually kind of from a legal perspective, when you're putting that disclaimer there, you're basically admitting that you're infringing on someone else's copyright. So it's a horrible misconception. Again, it can matter as one factor in a copyright lawsuit, but there's no automatic license or exemption just because you're not selling something or charging money for it.
Okay.
The last thing I would mention as far as copyright lawsuits, and again, everything we've been discussing today is US copyright law, which is federal law, but it varies in other countries. So if you're interested in the way that it works in the UK or somewhere else, you would want to check that out. But in the US, the statute of limitations, which means the time that you have to file a lawsuit, is 3 years from the date that you either knew about the infringement or should have known. So if it's a hit song that's all over the radio and all over the Billboard charts, most likely they're going to count that 3 years from the date that it was released. So you do have to move somewhat quickly if you want to bring a copyright infringement lawsuit. So if someone steals from you, you have 3 years from the time that they did it to file the lawsuit.
Okay. All right. And would you ever recommend people sort of trying to take things on themselves, sending a tweet saying, "Hey, that's my song," or an email or something? Or would you say, "Nope, go directly to your attorney"?
I think it's always best to have it go through the attorney just because some of this stuff, it gets very technical, and if it's not done in exactly the right way or within the right time frame, you can lose out, just based on technicalities. And also, people tend to take it more seriously when it comes from a lawyer for these types of things. So I would recommend, reaching out to your lawyer, having them send a letter and, following up on it. And this way you can, if you need to go all the way through and file a lawsuit, you can make sure it's done before that 3-year period runs out.
So you had the brilliant idea to ask the general public what they wanted us to discuss. And when I say us, I really mean you, of course. And there were a few responses that came in, I believe. Do you want to just run through them and we'll try to tackle them as best we can?
Sure. Yeah. So appreciate everyone that sent in suggestions. They're all great topics. Let's see. The first person asked how to navigate the independent space and if it's possible to win the independence game, owning masters, publishing, etc. So this is a great question, which I think probably could be its own talk in and of itself. So maybe Janae and I will plan in the future to go in detail with this because more and more artists nowadays are choosing to go the independent route, especially because a lot of the roadblocks in the past don't really exist anymore. So, for example, things like physical distribution and manufacturing, it used to be you kind of had to sign with a label in order to get CDs or vinyl or cassette tapes manufactured and into stores. And now everything's digital and it's very easy to get it online. So a lot of artists are choosing to stay independent. And I think overall, the thing to keep in mind if you decide to go that route is you really need to operate like a business. You need to be not only an artist, but also a business person. And I think that, a lot of these topics, Janae and I have covered it in prior talks, things like registering your trademarks, registering your copyrights, setting up an LLC, these types of business things that you can do to really help get yourself protected and established as an independent artist. So I would suggest, taking a look at those prior talks as a primer, and then maybe sometime soon, Janae and I can do another talk, Janae, if you're up for it, to specifically maybe discuss some tips for artists that want to stay independent.
Absolutely, because as you know, I'm on this journey with everyone, and even though I've said this a million times with our talks, even though I have you directly in my ear, it's still very, very complicated, and there's a lot to think about, and organization is key, which I know we talked about that in a previous topic. So, yeah, absolutely, people should go back to our previous discussions because we definitely covered a lot of ground, but I'm more than happy to have a conversation about that stuff again, maybe in a different way, and so that people can get it better.
Great. All right. Second question. This is a great one. The question was the ways in which having a lawyer involved will ultimately help you save money. So I love this question, and it's very true. I mean, a lot of people sort of shy away from hiring a lawyer because they don't want to put the cost into it, but it can end up costing you a lot more in the long run. So we discussed one example today with copyrights where, if you don't register your copyright on time, it can end up hurting you a lot if you ever need to bring a copyright lawsuit. Also, you might have a contract presented to you and you don't want to put the cost into having a lawyer review and discuss it with you. And so you may not understand exactly what you're signing, and that could end up costing you a lot of money in the long term. So, definitely it's an investment again, but you need to treat it as a business, and so you have to make sure that you're protected, and having a lawyer involved early on is a great way to do that.
100% agreed. And again, we did have a discussion about that and where finding a lawyer comes in the process. And we both agreed that it's really early.
Yeah.
It's don't even think about collaborating with anybody until you speak with a lawyer.
Yep.
So we can absolutely go over that again.
Great. Next question. I am a manager and a producer. Deal types and the suitable deal for an artist or producer, and what you should know before signing the deal. So, this I think is a very complicated topic because there's a million, especially nowadays, there's a million different types of deals. So, it's going to depend a lot upon what your goals are and what type of leverage you have as an artist or a producer. So this one, I would say we should also probably revisit later when we can get kind of more in depth into this. But it's a great question, again, especially because there are so many different options available now that a lot of times people just don't know which way to go.
Definitely. This is going to be really interesting.
All right, great. And then the last question, anything on legal promotion of independent artists and micro labels? So I actually do not really handle any marketing and promotion. To me, it's one of the more difficult aspects of the music industry because, you can get everything set up the right way. You can have great music. You can do all the legal stuff that you need to do, but then it comes down to how you're marketing it and promoting it to be able to get it out there for people to hear it. So it's not my area of expertise, but it is a very, very important thing to consider. So it's good that someone is bringing it up because you don't want to put all this money into recording the music and getting the legal stuff set up and not put money into marketing and promotion and have no one hear it. So it's a very important aspect to think about and to budget for, and to do the right way. But it's just unfortunately not my area of expertise.
And I feel like that's a little out of our scope, really, for what we're doing. However, it's a great question. I wonder if we could find somebody that is their expertise, and the three of us could have a conversation.
That would be great. Yeah.
Okay. That one will probably take a little longer because we've got to figure out who. But yeah, that would be really interesting.
Yeah. It would, because I have a lot of admiration for the people that are good at that because it's very difficult.
Yes.
All right. Those were all the questions. So again, if anybody who submitted a question is listening, thank you for your input. It's helpful and gave us some good ideas of things to talk about in the future. And I'll keep everyone posted about when Janae and I have those future chats.
So, I think that about does it. This was wonderful as usual. I need you to do your thing where you tell everybody how to contact you.
Sure. So the easiest way is to go to my website, which is cspanglermusiclaw.com. And from there, you can find email, phone number, everything you need. You can also find me on Instagram, cspanesq, facebook.com/music attorney. But really, the easiest thing is to go to my website and then you can find everything else from there. And again, it's cspanglermusiclaw.com.
Excellent. And of course, I will have that down in the description.
Great. Thanks as always, Janae. It was great speaking with you.
Oh my gosh, this is always a wonderful thing. And I always say it, but I always learn something new, which don't know how that's possible because we've had so many discussions. But yet something new keeps coming up. So I so appreciate you, Cassandra. Thank you very much.
No problem.
Thanks for listening to our conversation. If you have a topic that you would like us to consider discussing, just drop it in the comments section. Also, don't forget to like and subscribe to the channel.